A crucial panel discussion titled as Institutional Responses to Femicide and Gender-Based Violence, Operational Obligations under Articles 2, 3, 8, and 14 of the European Convention on Human Rights. Femicide and gender-based violence represent a grave violation of human rights, and it is our collective responsibility to address this pressing issue with utmost urgency. As we delve into the subject matter, we will explore the operational obligations outlined in these articles. These articles serve as a guiding framework that places important obligations on institutions to prevent, protect, and provide justice for victims of gender-based violence. And our moderator and speakers are Mirjana Lazarova Trajkovska, judge on the Supreme Court of North Macedonia and former judge of the European Court of Human Rights. Then her speakers, and yours as well, Ivana Jelić, judge on the European Court of Human Rights from Montenegro. Ioannis Ktistakis, judge of the European Court of Human Rights from Greece. And at the end, Robert Spano, president of the Board of Patrons, former president of the European Court of Human Rights, and partner at Gibson Dunn from Iceland.
Thank you, Ognen. Good morning, dobro jutro, dobro utro, and merdita to all of you, judges, prosecutors, colleagues from the region. I have honor to moderate this first panel today. And I must say that I have indeed great honor to introduce the panelists at the beginning of this panel, because as you know, the three panelists are judges acting now at the European Court of Human Rights and the former president of the European Court of Human Rights as well, Judge Robert Spano. But before that, allow me to express my thankfulness to the government of United Kingdom and to the AIRE Centre for their work and for their commitment for the gender equality in Balkan countries. We could hear this morning from the speakers and from the speech of the President Shifra Oliri how important is gender equality in the judiciary. And from that, we can see that the gender equality is important in the institutions, where we should see equal treatment to women and men, but also we are looking for gender equality from a side of the functioning of the institutions. And that's why I think that this first panel is important for our discussion, but also for the outcome of this forum today. How important is this forum, you will see from the fact that we have among us 5 judges that are sitting in the court in Strasbourg, led by the president of the court, and also 3 former judges, and among us also former president of the European Court of Human Rights. But at this stage, let me start by introducing the 3 panelists. I have an honor to introduce you Judge Ivana Jelić. She is judge in respect of Montenegro in Strasbourg, but also we all know her for her academic work. She is professor, she was professor in Montenegro, but also teaching in several universities across the globe. Judge Ivana Jelić was also active when it comes to the gender equality. She was rapporteur for the advisory panel on the European Framework Convention for the Protection of National Minorities. She was very active also as a member and also vice chair of the UN Human Rights Committee in Geneva, and that is where I've met, in fact, Ivana some years ago, before she became a judge in Strasbourg. Our second panelist today is my colleague and friend, Ioannis Ktistakis. I apologize, Ioannis, for wrong pronunciation of your last name. Ioannis is a university professor. He was a professor in several universities in Greece, but also at the Bosphorus University in Istanbul. He was also member of the Executive Board of the European Centre Against Racism and Intolerance, and also he was a substitute member to the Venice Commission in respect of Greece. Both my colleagues were very productive in writing articles in several books, in editing articles in connection with gender equality. And our third panelist today, the former president of the European Court of Human Rights, Robert Spano, is also with academic career behind him. He was professor and also dean at the Faculty of Law in Reykjavik in Iceland, but also he was ombudsman in the Parliament of Iceland. So he is also with practical experiences when it comes to the gender equality. Now he works as a partner in international law firm, and we are very grateful to him because despite his busy schedule, he is here together with us. Coming back to the topic of our first panel, let me say that we could hear from the previous speakers, but mainly from the case law of the European Court of Human Rights, that functional institutions are of key importance for establishing gender equality in our countries, mainly in Western Balkans, because we are together here for the benefit of the courts and institutions in Western Balkans. And that's why we will focus now in this panel precisely on how institutions should function, how institutions should prevent, and how they should fight against domestic violence or gender-based violence. And in this respect, I will turn to Ivana because she will start the panel discussion this morning. And I would like to pose you one, I would say, inspiring question, and then you can continue with whatever you think will provoke the discussion. We could hear today that countries do have positive obligation, and they have obligation under Article 2, 3, 8, but also Article 14 is involved in the proceedings at the national level and at the national level. Could you please tell us what are the positive obligations and what is the threshold when countries should start to react? And as we could see from the case law of the court in Strasbourg, the elements linked with Article 3 in human degrading treatment are not always linked with the physical abuse. So they go also beyond physical abuse, bearing in mind a new forms of exposing women to psychological violence, mainly online through internet. And we all have cases in front of our courts when it comes to the sexual abuse of minors under 14 years. And also we have many cases of pornography linked with minors. So could you please give us a little bit more light how the Strasbourg is approaching to all these questions, and maybe a little bit, even a little bit more. Thank you, Ivana.
Evo, ja ću iskoristiti da govorim sa govornice, prosto tako mi je jednostavnije, ne zbog toga što sam bila profesor prije ovog posla, nego zato što stvarno želim da vas sve najtoplije pozdravim i da zahvalim svima koji su upriličili ovaj važan forum, prije svega naravno AIRE Centru i gospođi Braithwaite, koji su i prošle i ove godine pokazali jednu opredjeljenost ovim važnim pitanjima. I mislim da isto tako Evropski sud za ljudska prava je dao odgovor i prošle i ove godine, ne samo velikim prisustvom sadašnjih i bivših sudija u vrijeme veoma, da kažem, zgusnute agende radne, nego i izlaganjima i učešću u svim ovim pripremama. I zbog toga posebno zahvaljujem svima. I naročito, evo ja sam danas odlučila da svojim maternjim jezikom govorim, za razliku od prethodnih foruma, zato što je ovo jezik koji se u ovom regionu najbolje razumije, i zbog toga što u svom svakodnevnom radnom životu baš nemam mnogo prilike da govorim svojim jezikom. Hvala sad još jednom, moram to reći, našoj predsjednici Šifri Oliri i predsjedniku borda patrona Robertu Spanu i naravno rekla sam svim ostalima zato što su, da kažem, ovom događaju dali značaj i u ime naše institucije, kao i sve sudije koje su tu. I hvala vama koji ste ovdje, puno prijatelja vidim među vama, evo sad možda ovaj neki balkanski naš emotivni način, ali puno prijatelja, puno kolega, saradnika i hvala vam što ste tu. Pa evo danas se bavimo pravnim aspektima mnogo šireg i duboko zabrinjavajućeg društvenog problema, to je femicid, i govorimo o nasilju u porodici, rodno zasnovanom, rodno orijentisanom nasilju. Ja sam pripremila nešto da vam kažem, ali ću odgovoriti naravno i na pitanja koja je naša uvažena moderatorka sudija Mirjana postavila, kako bismo diskusiju podstakli i naravno na raspolaganju sam oba ova dana kao jedna od patrona ove mreže da razgovaramo o svim tim pitanjima. Rizik koji predstavlja femicid i rodno zasnovano nasilje za prava i dostojanstvo žena i potenciram riječ dostojanstvo, ne može se podcijeniti. On zahtijeva posebnu pažnju i djelovanje svih, a posebno lokalnih vlasti, onih koji su najbliži svakodnevnim životima žrtava, potencijalnih žrtava, prije svega žena i djevojčica, djevojaka, jer tu sve počinje i na kraju kad dođe do našeg suda mi možemo samo govoriti o posljedicama koje su najteže i često tragične. Femicid kao namjerno ubijanje žena na temelju njihovog pola i rodno zasnovano porodično nasilje obuhvata različite oblike zlostavljanja. I Mirjana je to lijepo, rekla bih, uvela, ne samo zlostavljanje unutar intimnih odnosa, već i psihičko, psihološko zlostavljanje, razne traume i u posljednje vrijeme imamo situacije i ovog cyber nasilja gdje su žrtve djevojčice i žene. Mi se svi moramo sa tom sumornom realnošću suočiti kao društvo. I naravno, pravni odgovor koji se očekuje od sudija, bilo nacionalnih, i tu je najveće težište, najveći je posao na vama i mi samo u skladu sa principom supsidijarnosti kasnije reagujemo korektivno, nadajući se da će biti sve manje potrebe za sudom u Strasburu da korektivno reaguje u tim situacijama. Međutim, nediskutabilna je naša nepokolebljivost, nepokolebljiva predanost i za poštovanje ljudskih prava i za poštovanje svih sloboda i jednakosti. I ona zahtijeva sveobuhvatan pristup pozitivnoj obavezi država, pozitivnoj obavezi da zaštiti žene. Evropska konvencija o ljudskim pravima služi kao vitalni okvir za borbu protiv svih ovih problema, ovih pitanja. On nameće operativne obaveze državama članicama da preduzmu mjere koje štite živote i integritet žena i djevojčica. I ja sam zaista uvjerena da obaveze država ne bi trebalo da budu ograničene samo na sastavljanje izvještaja, na razne statistike, već one moraju da aktivno se angažuju u spriječavanju, istrazi i kažnjavanju akata nasilja nad ženama. Kroz zakonodavne mjere, jednak pristup pravdi i društvene promjene možemo zaštititi prava žena i eliminisati rodno zasnovano nasilje. Danas ovdje ispitujemo ove obaveze u skladu s Evropskom konvencijom o ljudskim pravima, analiziramo izazove sa kojima se suočavamo i razgovaramo i, naročito ćemo sjutra, o strategijama kako da osiguramo sigurniji, pravedniji pristup svim slučajevima femicida i nasilja nad ženama. Ja ću govoriti o nekoliko stvari. Jedna od njih je suštinska obaveza, operativna obaveza države da spriječi nanošenje povrede. Kao što znate, Osman test, uspostavljen u predmetu Osman protiv Ujedinjenog kraljevstva, i o tome smo pričali kad smo pripremali ovaj panel, odnosi se na dužnost države da zaštiti pojedince od nasilja trećih lica. Ova obaveza je proširena na femicid i rodno zasnovano nasilje. Opseg ove dužnosti u vezi sa nasiljem u porodici detaljno je razrađen u predmetima Opus protiv Turske, Kurt protiv Austrije i Talpis protiv Italije. U kontekstu femicida i rodno zasnovanog nasilja, Osmanov test zahtijeva procjenu da li je postojao stvarni i neposredni rizik po život osobe za koju se zna da je u opasnosti i da li su vlasti znale ili su morale da znaju za taj rizik i da li su one preduzele razumne mjere da to spriječe. Test razmatra operativne dužnosti za procjenu rizika i sprečavanje štete. Početni korak ovog testa je da se ispita trenutni odgovor vlasti po prijemu navoda o nasilju u porodici. On zahtijeva da se sprovede nezavisna, proaktivna i sveobuhvatna procjena kako bi se utvrdilo da li postoji stvarna i neposredna opasnost po život identifikovanih žrtava nasilja u porodici. I prilikom procjene rizika treba uzeti u obzir specifične okolnosti slučaja i za to naročito bih rekla da je uputan predmet Talpis protiv Italije, naročito stav 122. Dakle, konkretne okolnosti su važne. Ako rezultat procjene rizika ukazuje na stvarnu i neposrednju prijetnju po život, onda drugi dio testa dolazi u obzir, a u ovoj fazi nadležni su dužni da sprovedu preventivne operativne mjere koje su odgovarajuće i srazmjerne stepenu identifikovanog rizika. Dakle, srazmjernost je ovdje ključna. Upotreba ovog testa u slučajevima nasilja u porodici je princip princip koji sud slijedi u ovakvim predmetima. Međutim, ipak se mora naglasiti da upotreba ovog testa nije imuna na kritike i kad smo pominjali kritike, to je i naša predsjednica pomenula. Mi smo osjetljivi kad čujemo kritike, naravno, i razmatramo ih i mi znamo na šta posebno treba obratiti pažnju i da kažem i u samim redovima suda i naročito se to vidi kroz izdvojena mišljenja. Na primjer, u predmetu Volodina protiv Rusije sudija De Albuquerque je utvrdio da test primijenjen na nasilje u porodici ne ispunjava svoju svrhu. U striktno shvaćenom Osmanu stvarni i neposredni rizik implicira, ovo je sad citat, da je počinilac već u neposrednoj blizini žrtve i da će pokrenuti prvi čin nasilja. Za ovog sudiju primjena testa na ovaj striktan način izaziva dvije zabrinutosti. Prvo, svaka zaštitna akcija koju bi preduzela država bi došla prekasno, što bi učinilo tu akciju neefikasnom, nedjelotvornom. I drugo, država bi mogla da iskoristi izgovor za nepraktičnost, jer je realno očekivati da žrtva bude stalno u pratnji državnog agenta koji može da interveniše i da uvijek sve iskontroliše. Stoga, zahtjev neposrednosti, immediacy, u Osmanovom testu možda nije najefikasnije riješio pitanje nasilja u porodici. U slučaju Talpis protiv Italije i jasno u predmetima Tunikova i drugi protiv Rusije, sud je odstupio od striktne primjene principa Osman. Standard due diligence koji se koristi u Talpisu za procjenu postupaka i nečinjenja država pokriva širi vremenski okvir, počevši od tačke kada je rizik od nasilja u porodici prisutan, kada je dakle on konstatovan, ali još uvijek nije neizbježan. U predmetima Tunikova i drugi protiv Rusije sud je primijetio, i sad citiram, u procjeni neposrednosti rizika vlasti treba da uzmu u obzir specifične karakteristike slučajeva nasilja u porodici, kao što su uzastopni ciklusi nasilja, često sa povećanom učestalosti, intenzitet i opasnost tokom vremena. I to je kraj citata. Sud je u svojim nalazima uskladio mišljenja i sa drugim međunarodnim instrumentima i to je važno reći jer želim da vi znate, to proističe iz svih naših obraćanja, ali prosto da se zna da je evropski sistem zaštite ljudskih prava dio opšteg sistema zaštite ljudskih prava i da mi veoma mnogo obraćamo pažnje i na ostale izvore i univerzalnog i ostalih partikularnih, regionalnih dakle, zaštita ljudskih prava. I u tom smislu često, dakle, se oslanjamo i na druge instrumente, kao što je stav SIDO o tumačenju neposrednosti rizika, recimo. Sud je ponovio posebnost slučajeva nasilja u porodici u olakšavanju testa dokazivanja koji pada na žrtvu i u predmetu Volodina protiv Rusije zaključeno je da u slučajevima kada je utvrđena značajna strukturalna pristrasnost, pojedinačni podnosioci predstavke nisu obavezni da dokazuju individualnu predrasudu. ovakva presuda ženama nudi jedan pristupačniji put ka pravdi, prepoznajući sistemske barijere sa kojima se suočavaju i olakšavaju teret koji žrtve snose. Povećani obim zaštite prava žena se proteže i na više od prijetnje po život, naročito u kontekstu članova 2 i 3 koje je Mirjana pomenula, i tu se uključuje i zaštita pod članom 8 i ja ću se sada malo više na to osvrnuti. Obim povreda i nasilja koji potpadaju pod član 3 i 8 uključuje, na primjer, i prijetnje ubistvom i strah od povrede. Obim povrede i nasilja koji potpadaju pod ove članove, dakle, je jedan širok spektar povreda i znamo kad govorimo o članu 3 da prije svega mislimo na fizičko nasilje, na seksualno nasilje, na psihičko zlostavljanje i bilo koji tretman koji uzrokuje tešku patnju i poniženje. Stepen patnje je vrlo važan u svim tim individualnim asesmentima kad govorimo o konkretnom predmetu. Obim člana 3 prirodno se proteže i na silovanje i na seksualno zlostavljanje i tu imamo predmet EB protiv Rumunije iz 2019. BV protiv Belgije iz 2017. Ali proteže se i na maltretiranje putem interneta u kontekstu nasilja u porodici. I tu imamo predmet Buturuga protiv Rumunije na koji vas upućujem. On je iz 2020. i tu imamo povredu člana i 3 i 8 u smislu propusta države da svoju pozitivnu obavezu ispuni. Institucionalni odgovori na kršenje osnovnih prava od strane privatnih pojedinaca treba da se pozabave ovim ponašanjima prema ženama i djevojkama uz pojačanu kontrolu. Važno je napomenuti dva razvoja događaja u vezi sa ocjenom suda u pogledu slučajeva nasilja u porodici prema članu 3. Prvo, u predmetu Volodina protiv Rusije i kasnije Tunikova i drugi protiv Rusije postavilo se pitanje da li neuspjeh države da interveniše u porodičnom nasilju treba da se kvalifikuje kao nehumano i ponižavajuće postupanje i mučenje. U svom odvojenom mišljenju takođe sudija je, kao što sam već navela u predmetu Volodina protiv Rusije, tvrdio da sud ne bi trebalo da oklijeva da neke radnje nasilja u porodici koje se dešavaju zbog neaktivnosti vlasti kvalifikuje kao mučenje, posebno kada vlasti nisu mogle da ignorišu, nisu smjele da ignorišu namjernu prirodu štete koja je nanijeta žrtvi. Argument nailazi podršku u mnogim instrumentima međunarodnog prava o mučenju, posebno opštem komentaru broj 2 u KATA i ovaj pristup, međutim, nije uvijek ispoštovan i vidjet ćete recimo u predmetu Tunikova i drugi protiv Rusije, konkretno u stavu 77. Drugo, slučajevi nasilja u porodici nisu imuni na opšti fenomen proceduralizacije ljudskih prava. I u predmetu J.I. protiv Hrvatske sud je istakao odgovornost vlasti da zaštiti posebno ranjivu žrtvu u skladu sa procesnim dijelom člana 3. Utvrđeno je da su hrvatske vlasti prekršile svoju obavezu da efikasno istraže navode o ženi koja je pretrpjela traumatično iskustvo porodičnog nasilja. U predmetu Tekiladže protiv Gruzije, i tu sad znamo, bili smo u istoj sekciji, sud je utvrdio da kada je šteta djelimično rezultat nečinjenja organa koji prevazilazi nepažnju ili puku grešku u procjeni, proceduralne obaveze zahtijevaju pokretanje krivične istrage o ponašanju organa za sprovođenje. Ovu obavezu svakako ne treba zanemariti kada navodna žrtva ukazuje na nedostatke u postupanju organa za sprovođenje zakona. U tom smislu važno je napomenuti da Istanbulska konvencija zahtijeva od država da uspostave mehanizme zaštite koji ne zavise od inicijative žrtve i tu prije svega mislim na član 14 stav 4. Propust da se preduzmu preventivne mjere za sprečavanje povrede koja je ispod granica ozbiljnosti, to je taj severity threshold u pogledu člana 3, može dovesti do razmatranja pitanja i ovog problema po članu 8 Evropske konvencije koji obuhvata pravo na porodični i privatni život. A ovdje govorimo o fizičkom i psihičkom integritetu i to uključuje zaštitu od prijetnji po život i integritet. Strah od povrede, dakle strah, kada duša pati, kada vam se stavlja u izvjesnost nešto što vam stvara realnu ili čak možda i nerealnu bojazan, ali kada postoji realni rizik, strah od povrede također može da potpadne u djelokrug člana 8, jer može da ometa nečije uživanje u privatnom i porodičnom životu. Na primjer, opet imamo primjer Hajduova protiv Slovačke, propust vlasti da reaguje nakon dokazane prijetnje upotrebom nasilja je u suprotnosti sa članom 8. U predmetu MM protiv Hrvatske, sud je zaključio da član 8 je zahtijevao povećani nivo brige zbog umiješanosti traumatizovanog djeteta koje je zbog spornog odnosa između roditelja iskusilo značajan emotivni stres koji je doveo kasnije do povrede i do samopovrede. Konačno, u predmetu Volodina protiv Rusije broj 2, sud je identifikovao da akti cyber nasilja, poput prekomjerne upotrebe funkcije praćenja i prenošenja prijetnji smrću, predstavljaju veoma ozbiljno kršenje integriteta žene i dijela koja zahtijevaju krivično gonjenje. Ovim sada uvodnim dijelom ja mislim da je i odgovoreno na ova pitanja koja je Mirjana postavila. Ja bih nešto isto rekla više možda i o faktorima, ali evo da to možda ostavimo za kasnije, samo bih eto možda tu potencirala da prilikom procjene da li je došlo do povrede operativne dužnosti sprječavanja štete, pravosuđe mora uzeti u obzir nekoliko ključnih faktora. Ovi faktori uključuju predvidljivost štete koja procjenjuje da li su vlasti mogle razumno predvidjeti rizike sa kojima se suočavaju uključeni pojedinci, ponavljanje žalbe, svjedočenja pouzdanih svjedoka, znaci zavisnosti od supstanci od strane navodnog počinioca, vidljive traume i sveukupno pogoršanje mentalnog zdravlja navode žrtvu često da služi kao pokazatelj tekućih akata nasilja. I, na primjer, značajni slučajevi kao što je Tehiladže protiv Gruzije razotkrili su nemar vlasti u razmatranju dokaza o nasilju u porodici od strane roditelja navodnog počinioca. Nereagovanje na osnovu takvih dokaza pokazuje kritičnu grešku u sistemu koji zahtijeva hitno preispitivanje. Adekvatnost preventivnih mjera nakon prvih dokaza nasilja u porodici postaje ključna u određivanju da li su preduzeti odgovarajući koraci da se spriječi šteta. I onda mjere dalje moraju biti proporcionalne. I još samo jedan bih predmet navela, onako iz prakse, u tom smo predmetu učestvovali neki od nas, tragični slučaj AB protiv Gruzije koji ukazuje na femicid od strane policajca. I ovaj slučaj je, recimo, ukazao na potpuni nedostatak djelotvornosti domaćih zakona koji štite žene od povreda. Utvrđeno je da vlasti ne samo da nisu ispunile svoju obavezu da zaštite život, već i nisu uopšte reagovale da zaustave ciklus nasilja u tom kontekstu. Tako da ovi slučajevi služe kao upečatljiv podsjetnik da je potrebna društvena promjena i da je potrebno da se uključe mnogi, a ne samo na kraju sudovi, kako bi se efikasno uhvatili u koštac sa pitanjima femicida i nasilja u porodici, nasilja koje je naročito upućeno ka ženama i djevojčicama.
Hvala, Ivana. Ja bih krenula tamo gdje ste vi stali. U principu sudovi nastupaju na kraju. Ono što je važno je institucionalna akcija još od početka kada se prvi signali pojave ispred institucija koje su vrlo često socijalni radnici, psiholozi, pa i pedagozi, kada je reč recimo u nekim ustanovama. Hvala vam puno. Now I will turn to Robert because that what you've mentioned is somehow overlapping with his, yes, please. Robert, you can stay in your place if you feel more comfortable, or you can go on the stage, it's up to you. And you know, I was listening very carefully, Ivana. She has provided us with useful overview of the Osman test and the duties which are arriving from the case of Osman. Perhaps it will be useful to give us some more information about the distinction between cases where a woman is a victim and how Article 14 is coming into play, because it's not enough to say that we have case in front of us under Article 2, 3, or 8. It was mentioned by President O'Leary also, Article 14 and Protocol 12 are important for cases linked especially with femicide. So could you give us a little bit more information about the interplay of Article 14, Protocol 12 with Articles 2, 3, and 8? And maybe you can give us a little bit more food for thought about domestic violence and how to react, what is our experience from the cases in Strasbourg. I know that you have also experiences from the national institutions, being ombudsman once in your career, but mainly, please give us a little bit more elements about this interaction between Article 14.
Thank you very much, Mirjana. I think it's best to answer that question with sort of 4 points. The first is a historical point. The second, a conceptual point, because I think the distinction between individual applications under the provisions of the Convention in Article 14 is also conceptually a bit different. Thirdly, let me say a few words about sort of the main substantive principles under the case law. And finally, I want to make an important procedural point. So historically, in 1992, in General Comment 19, the Committee on the Elimination of All Forms of Discrimination Against Women under the UN Convention, for the first time categorized gender-based violence as constituting discrimination against women under Article 1 of the Convention. In 2017, in General Comment 39, the same committee made or declared that gender-based violence as a form of discrimination now had attained the status of customary international law, which is a very interesting development. And in the interim, you see the European Court of Human Rights use this development within its case law. Of course, the landmark judgment in relation to discrimination under Article 14 is Opus versus Turkey. That's sort of the first case where the court, in a general manner, conceptualizes, and this is my second point, the concept, conceptualizes discrimination against women when it comes to gender-based violence as a form of group-based discrimination. It's a different analysis under the law from the analysis that we adopt when we're looking at an individual application. And what do I mean by that? What I mean by that is, when it comes to discrimination against women, we are looking at it from the lens of group-based forms of discrimination. The claimant does not have to demonstrate discriminatory intent in the particular circumstances of his or her case. It is enough to demonstrate a prima facie case that statistically there is a disproportionate tendency to discriminate against women in the legal system. So that conceptual difference is a very, very important point to make. The third point that I would make, the substantive principles, I think there are 3 judgments which are very important for our purposes. They have all been mentioned by Ivana. The first is Opus versus Turkey. Then we have 2 chamber judgments, Talpis versus Italy, which is a very important judgment in this respect. But the one I want to focus on is the judgment, a chamber judgment of 9 July 2019 in the case of Volodina versus Russia. The reason I think it is a very good judgment, because in paragraphs 119 to 114, the court gives a consolidated overview of the principles underlying discrimination under Article 14 in this sphere. I just want to mention that Kirtby, Austria, which is the Grand Chamber judgment on the operational principles under Article 2 when it comes to domestic violence, did not include an Article 14 analysis, and that's a procedural point which I will want to make at the end. So there are two substantive principles which are crucial. The first is the distribution of the burden of proof. Now, usually in a classic discrimination case, a claimant has to demonstrate difference in treatment, and ultimately then the difference in treatment has to be demonstrated on the facts of a particular case. Now, when it comes to discrimination against women in the form of group-based discrimination, the prima facie case that has to be made is there is a disproportionate burden on the group itself, which can be relied on statistical reporting. It can rely on country reports, reports of international human rights organizations. It can also be based on information received by the parties on a particular case, which can be expert opinion and so forth. All of these various reporting types come into play in these cases. Now, if the claimant demonstrates a prima facie case, it is for the government to demonstrate that they have put in place remedial measures at national level to counter the disproportionate tendencies in the system. Now, for example, in Opus, the Turkish government was not able to demonstrate that. On the flip side, in Talpis versus Italy, we considered, I was in that case, Ledi as well, we considered that Article 14 was not violated because there wasn't a demonstration of the lack of remedial measures. In Volodina versus Russia, there was a violation of Article 14. And the final procedural point that I would make is the conceptual distinction that I just made at the outset makes it clear that if an individual applicant complains under Article 2, 3, or 8, we will not, I mean, I'm still saying we after 7 months in the court. I've left the court. Sorry about that. It will go away. Give me a bit more time. The European Court of Human Rights has taken the position, which it did in Kurt v. Austria, that it will not understand an individual complaint under Articles 2, 3, and 8 automatically as including a discriminatory complaint under Article 14 because there is a conceptual difference. So that's why in Kurt v. Austria, the Grand Chamber dismissed the Article 14 complaint because the court did not consider that it was inherently included in the individual complaint of the applicant. And that again shows the conceptual difference. But Article 14 is a very, very powerful tool in the discriminatory context. But of course, I agree completely with the President, who is an expert on discrimination law, that we still have, the court still has a lot of work to do in this field. And I think that's why this conversation is very important. Thank you very much.
Thank you very much. I have one short question. I'm inspired by your speech. I agree with you that Article 14 does bring a new quality of the cases in connection with femicide and gender-based violence on a general basis, because it does show the difference between female and men who are part of the case, because it might be men, as we've heard this morning. It's generally, we are speaking about women when it comes to the gender-based violence, but when we speak about discrimination, then we see, like in Konstantin Markin, men can also be victims. So when we are speaking about analyzing the cases through lens of Article 14, together with Article 2, 3, 8, it depends on the case, then do you think that national statistics and the way how the case will be supported with statistics does help the court to come with finding violation on the basis of Article 14? Because as you said, in one of the cases, there was no violation on Article 14. But this morning, we could hear from Mirjana and also from the rapporteur from UK, Angela, that statistics are really shocking, and they are deeply disturbing. If 75% of women in Europe are complaining that they have been exposed to some kind of violence, then what do you think, how we should approach to this question of statistics on the national ground, and how they can be used in a most productive way in front of the court, from your experiences in these two cases?
Can I just make one preliminary point when I answer this question? We have to make a distinction between cases where the court finds a violation of Article 14 and 8 in an individual application context, like the case of Beller versus Switzerland, which the President mentioned, where you have an individual applicant, a male in that regard, a widower, that makes a claim under Article 14 and 8, where there is no claim of necessarily group-based discrimination in the manner that I suggested just now. There, you're looking at the application of the law to the facts of the individual case, and you're looking at whether there is a lack of justification in the difference of treatment. When it comes to group-based discrimination, which of course is difficult to make, although not impossible, difficult to make, it's usually women that can make that claim because of the historical discriminatory intent vis-a-vis the patriarchy and all of what was mentioned. Then statistics for example, statistics in relation to how the police reacts to claims or criminal complaints by women. Statistics that demonstrate judicial passivity to claims of discrimination at national level. Statistics that demonstrate complete lack of training in the legislative and the judicial and executive spheres at national level. We have, and maybe we can be faulted, the court can be faulted for not taking an overly scientific approach to this. The court has been open to accepting from respectable organizations statistical evidence of the existence of disparities and group-based discrimination. And I think ultimately, looking at the way the court assesses evidence, that makes sense, but we have to be careful there to understand the statistical analysis in the correct way, to assess it in a manner which is reasonable on the facts of the case. But it is extremely useful because it allows the court to be more, let's say, systemic in its analysis under Article 14.
Thank you very much on this, because it is also linked with my starting question for our colleague Ioannis Ktistakis. This time I think I was pronouncing correctly. Robert was tackling above the issue of burden of proof, and burden of proof linked with statistics. I will say it does make a good ground for case also on the national basis, and then to build a case for Strasbourg if necessary. Well, my question, dear Ioannis, will be about the operational duty of the national institutions, not only courts, generally on the national institutions, and how to improve institutional approach in the region, because you are also coming from the region of South Europe. I prefer to say we are coming from South Europe, not only Western Balkans. And you know the problem of domestic violence also in Turkish society, in Greek society, but also in Balkan countries. What will be your view? How to improve operational duty of the national authorities? What might be done for, I would say, effective preventive approach toward domestic violence and especially femicide?
Thank you, Mirjana. In my view, there are two ways to proceed in a national level. The first one, I think, is the criminal framework. Before coming to Belgrade, I did a research, and I noticed that the last year there are more than 140 44 countries who have passed laws on domestic violence, and 154 countries who have passed laws on sexual harassment. Is this enough? No. Because the adoption of this specific provision doesn't mean necessarily compliance with the international standards and recommendations. And I think that the last Volodina case, the Volodina case number 2, the court has noticed that the the effective and, let's say, precise criminal framework is necessary for protecting the victims of, in Volodina number 2, the question was the cyber violence, if I can say, cyber affect violence. And the court in paragraph, I think it's the paragraph 89, the court emphasized on the necessity of precise criminal framework to prevent gender-based violence. But also concerning our region, I noticed that there are some countries like Romania, Malta, Cyprus, and Greece who have adopted a specific definition of gender-based violence. And this is very important. I remind that Grevio, in its first report in 2020, has criticized gender-neutral laws for failing to recognize that such violence disproportionately affects women and children at the hand of male perpetrators. And the first is to have an effective and precise criminal framework in the national level. My second, let's say, thought is about a main national mechanism to protect victims, which is the risk assessment. This mechanism can involve gathering detailed information about the victim, the perpetrator, and their situation, and then they define the risk level, the medium, standard, or high. This mechanism should be carried out using a standard procedure and within a multi-agents framework. Risk assessments outcomes should be directly linked to risk management strategies in the national level, and that help to ensure the immediate and ongoing safety and well-being of women and children. I want to emphasize that Article 51 of Istanbul Convention, which is the convention, let's say, applied in all these cases, Council of Europe Convention, explicitly obliges the authorities of the member states who have ratified this convention to carry out a risk assessment, including the lethality risk, the seriousness of the situation, and the risk of repeated violence, including perpetrators' access to firearms. If the national authorities, especially in Balkan, use a standardized risk assessment protocols with all these elements, I think that when the file of the case will be brought before the national courts or at the latest level in Strasbourg court, there will be all the elements, all the not only the minimum, but I say the maximum of the elements possible that the court, national court or Strasbourg court will examine in the certain case.
Thank you, Ioannis. But you've mentioned the region and a little bit, let's say, broader perspective, but can you provide any positive example where the operative duty was really implemented in a way that it came with the good results, if any, in the region or broader?
Yes.
Because as you mentioned, the Istanbul Convention is now the leading document, and we do see first results from Istanbul Convention at this moment. Maybe perhaps on this you can give us a little bit more elements.
Well, according to my research in the region, I think that I can mention a best practice example, which is the Prague Intervention Center, which this center conducts every victim of gender-based violence. They provide information on specialized services for victims of domestic violence and other types of physical and sexual violence or other criminal offenses, and they support all the families and by paying the lawyers and from the very beginning, and then have a complete file of the case. Probably there are other also centers, but I think that I was impressed during my research for this conference by this center, and we can say that Prague is also in the region, it's not very far from Belgrade.
Thank you, Ioannis. Thank you, dear colleagues. I now turn to our colleagues who are present in the room. We still have some time for questions, comments, or maybe you would like to share with you your experience about the institutional response to femicide and gender-based violence. So please feel free to pose questions or to comment, and if you would like to, who would like to start, please raise your hand and present yourself. Okay, I see here Valentina, but I know you, Valentina. The rest of the participants probably don't know who you are. Please present yourself.
Okay, I will present. Okay, I speak my mother tongue. Ja sam Valentina Pavličić, rani sudija, krivičar crnogorskog pravosuđa. Sada sam zastupnica Crne Gore pred Evropskim sudom. Slušajući vas danas, imam potrebu upravo iz razloga što bih željela da prenesem iskustvo Crne Gore u pogledu što je i sutkinja Jelić rekla, neke pozitivne obaveze koje država ima kada su u pitanju krivična djela gdje nam se kao žrtva pojavljuje ženskog pola osoba. Mi smo uradili noveliranje krivičnog zakonodavstva, međutim nismo uveli krivično djelo femicida. Ono što je ovim zadnjim izmjenama urađeno, jer je smatralo se tako da može da se odgovori toj pozitivnoj obavezi, jeste da nakon analiziranja kaznene politike koja se zadnjih godina u vezi sa određenom vrstom krivičnih dijela iz porodičnog nasilja ili krivičnih dijela protiv života i tijela gdje nam se kao žrtve pojavljuju osobe ženskog pola, da je ta kaznena politika bila blaga. U tom smislu povećan je raspon između tog zakonskog minimuma i zakonskog maksimuma kada su u pitanju krivična dijela gdje nam se kao oštećeni, jer mi i dalje imamo takav naziv, nemamo status žrtve, pojavljuju djeca, žene i kada su u pitanju nasilje u porodici. Korak dalje koji je otišao jeste i u pogledu procesnog zakonodavstva. Mi smo sada u procesu izmjena ZKP-a i tu smo ograničili da se na ovu vrstu krivičnih dijela ne može primijeniti institut sporazuma u priznanju krivice. Upravo zbog te analize koja je urađena. Također, da kažem da su tu i ova krivična djela protiv polne slobode uključena. Da li će to imati efekta u praksi? Ostaje da vidimo, ali zakonodavac, odnosno to je moja dužnost da prenesem šta je stav bio vlade, odnosno nadležnog ministarstva, jeste da u ovom trenutku u pogledu uvođenja kao samostalnog krivičnog djela femicida nismo našli adekvatnost, ne zato što smo protiv toga, već je tu upravo kolege koje se bave i konačno i ja iz svog nekog iskustva kao krivičar, jer sam imala u radu tu vrstu predmeta, upravo što može da dođe zbog tog namjere koja je neophodna kao subjektivni element krivičnog dijela biti problematična. Ali u ovoj godini mi smo preduzeli te mjere koje su neka vrsta pozitivnog efekta upravo koja je izrodila i od prošlogodišnjeg našeg foruma gdje smo razgovarali na tu temu. Eto, to sam htjela samo da se uključim, da postaknem diskusiju na tu temu. Hvala.
Hvala vam, Valentina, to je jako važno. To što ste pomenuli da ste između dva foruma ušli u izmenu zakonodavstva, znači da su ovi forumi inspirativni, da podstiču i da je u principu, na kraju krajeva to je i cilj, da mi uradimo nešto ili poboljšamo nešto u našim sistemima. Ja mogu još da pričam u ovom kontekstu, ali ja mislim da vi imate što da kažete i možete i da spodelite neka vaša iskustva ili da pitate moje kolege iz Strasbura, tako da opet se okrećem vama i da li neko još ima, evo izvolite koleginice. Before this, our colleague Ioannis will like to intervene.
Just because I have a look to the national legislation, and in response to these difficulties about femicide in criminal code, I found very interesting two provisions of the last year, one in Malta legislation and the second in Cyprus legislation. They both adopt a specific definition of offense of femicide, and I think that the one adopted in Cyprus is very precise, and well, I'm not a specialist in criminal law, but I think both the two, they are very interesting, especially the Cyprus one, because there is a specific now offense for femicide. Thank you.
It's yours, dear colleague. Could you present yourself? Or?
Yes, thank you very much. Altina Besimi, I am from Kosovo. I cover policies and projects in the rule of law area. I want to thank you all for your contribution. I've learned so much, even from very opening session in the first panel. Following what President O'Leary mentioned, Article 14, and then the former President, Mr. Spano, also re-mentioned that, I wanted to understand more when it comes to what actually does it mean the court has to do more regarding this specific article. I understood it is a powerful tool, but I think there was something which I missed and maybe skipped, so I really want to understand more. What is it that the European Court has to do more when it comes to the Article 14? Thank you.
I think as a preliminary point, it's important to understand the nature of Article 14. Article 14 is not a general non-discrimination provision. It always requires that an applicant demonstrate that there has been or there is a claim that that person can make under another provision. So Article 14 always works with other provisions of the Convention. It's different from Protocol 12, which President O'Leary discussed, which includes a general non-discrimination clause. So that's important. We often talk about Article 14 being what is not a very nice term, a parasitic provision. So it feeds off other provisions of the Convention. So what Article 14 has done in practice, it creates the opportunity for a claimant who thinks that a governmental measure has an impact on private life, family life, like the case of Konstantin Markin and the case of Beller, you know, widowers or military personnel, that family benefits, issues of that sort. And when it comes to violent activity, Article 2, when somebody loses their life, like a child or even a woman in a domestic relationship, or ill treatment under Article 3, then not only can you claim a violation of that particular provision, right to life, Article 3, prohibition against ill treatment, but you can claim that the context was a discriminatory context. And the way this plays out in the gender-based violence sphere is that Article 14 has been used and interpreted as imposing on member states a requirement to regulate their laws and their procedures, in particular in law enforcement, to eradicate discriminatory patterns and weaknesses in the system. So Article 14 has, to some extent, the use of it is, it doesn't just focus on the individual applicant and provides redress and remedies to that person, but it is also used as a systemic remedy. And that's a very interesting and not necessarily a development which was clear from the outset. It was not a foregone conclusion. So I think this is maybe to some extent the way in which the court has used Article 14 to assist in mitigating the relative weakness of Protocol 12, because it is a rather weak provision in the Convention due to the relatively limited number of ratifications and the fact that it's not very much used by applicants. So Article 14 has this dual purpose. It is meant to be a remedy for the applicant, the man or woman that brings the case, but it is also a repository of a systemic remedy, which is then meant to be implemented at a national level. I hope that that made sense.
Thank you very much.
I will give the floor now to the President O'Leary. She asked for the floor. President.
Many thanks for your question. I'll be very brief. First, as regards Article 14 generally, Robert Spano has mentioned one of its difficulties. It's accessory. We come to it at the end, and often we say there's no need to examine it separately. This has led, in my view, to a number of things. Our case law on indirect discrimination, positive discrimination, and intersectional discrimination is very underdeveloped. And most forms of discrimination in the third decade of the 21st century are no longer direct and overt. They're structural, disguised, and you have to root them out with a much more sophisticated discrimination tool. The convention is quite old now, and it's painted in very broad brush, unlike developed equality legislation, which allows courts to have much more teeth. That's the one general point. In the field of femicide, domestic and gender-based violence, I addressed this last year in my paper in much more detail, and I can't in my response go into the details. But there I think the court has some work to do, and I would have a slightly different position to Robert Spano, because some of the cases in which we have found violations of 14 plus 2 or 3 are cases in which the domestic violence in the state is so abhorrent, so widespread, that you couldn't but find a violation. But what about the other states? A very good example of this, I know it will be touched on by Judge Yüksel, is Y and others against Bulgaria. This was a case in which the punishment meted out by the courts was reduced, in which the state has not ratified the Istanbul Convention, but on the basis of the evidence provided by the applicant, the court found no violation. My point being that the evidentiary burden on the applicant is often very difficult for them to discharge, or the court's case law at present regarding when the burden of proof shifts to the state is not yet clear enough. But again, Judge Jelić will address this, I think, in her address, giving some more positive recent examples. And that's, I think, the direction in which we need to go. Remember, somebody who's claiming a violation of Article 14 is claiming this in relation to Articles 2 or 3, where the court has already found a violation by the state of its obligations. So it's a slightly different type of case than your normal use of Article 14, and Robert Spano has explained that very, very well.
Yeah. Thank you both. I think you can see, dear colleagues, from both answers that my colleagues are analytical, but also constructive, critical for the work of the court, which does help the court to fulfill the doctrine of living instruments. So we will wait for new cases in front of the European Court of Human Rights to see how this constructive criticism will be implemented. As it was already mentioned by President O'Leary, in the second panel we will have a chance to hear more voices from our colleagues from Strasbourg. I'm already receiving signals that we overlap the time for a coffee break. And here I would like to thank once again the panelists, former President Spano, Ioannis, Ktistakis, and my friend Ivana Jelić for their intervention. Thank you for your active approach.